Hi guys, this is editorial analysis for 7th October 2016. Let's go to the first one. This is from the Hindu newspaper. It says that the Union Cabinet has approved the HIV and AIDS Prevention and Control Bill 2014. It makes discrimination against people living with the virus punishable. So there are three noticeable points here. First of all, with the help of active monitoring by HIV/AIDS support groups, the bill can make it possible that infected people are able to get education, employment, housing, healthcare, etc. Secondly, it is going to take a high degree of commitment to provide effective drugs to all the infected, which are estimated to be 2.1 million in India, many of whom are women and children. Thirdly, the bill also ensures confidentiality of HIV status. And there are a couple of problems here in this regard. Firstly, that the insurance industry is allowed to use actuarial calculations to limit access to products to people with HIV. And secondly, National AIDS Control Organization, NACO, their data of 2015 shows that while there has been an overall decline in HIV prevalence in India, it has still increased in 9 states. So that is something on HIV and AIDS Prevention and Control Bill 2014. Let's move on to the second editorial. This is also from the Hindu. A rather boring read. It's a very long one. I'm just going to summarize it and make it really small. I'm just going to walk you through it. So it says, this is on the Singur land acquisition case. On 31st August, Supreme Court in Kedarnath Yadav versus State of West Bengal invalidated the expropriation of land in Singur by erstwhile left government in West Bengal, and the Supreme Court ordered that the acquired properties be returned to their original owners. It had violated the Land Acquisition Act 1894, which stands repealed today by right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act of 2013. So this Singur land acquisition, it had violated the Land Acquisition Act of 1894, which was still in force when it was done. Now it stands repealed by the new act, which is called Right to Fair Compensation and Transparency Land Acquisition, Rehabilitation and Resettlement Act of 2013. This was a momentous judgment which decided the extent of sovereign power to acquire property and what constitutes public property. So I'm just going to walk you through what happened in this entire case in case you don't know that. In the year 2006, the left government had acquired 1,000 acres of land in Singur for Tata Nano production unit, and it defended its move by saying that it will create hundreds of new jobs, and that was its public purpose. In 2008, the Calcutta High Court also agreed with the intent of the state. However, many small and marginal farmers who had refused to accept the compensation then went to the Supreme Court. Now let's see what the Constitution says about this matter. The original Constitution in Article 19, Clause 1, Subclause F guaranteed the right to property to all the citizens, subject to reasonable restrictions in public interest to acquire, hold and dispose of property. Article 31 in the original Constitution vested in the state an explicit power to expropriate property for a public purpose by paying compensation to the landowner, provided that such an acquisition was backed by a suitable legislation. Because of these two provisions, the judiciary after independence could review each and every case of acquisition. So, due to this judicial interference, the government diluted the right to property through the 44th Constitutional Amendment Act of 1978, which deleted both the articles, that is 19(1)(f) and 31. 19(1)(f) was deleted from the fundamental rights. However, it still remains a constitutional right. Right to property is just not a fundamental right now. And this was done in the name of land reforms and bringing in more equality by the government. But after this amendment, the 44th amendment, it was only used to perpetuate inequality, because then government used to acquire lands and give it to private parties in the name of public purpose in courts. So that's why the government in 2013 they introduced the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. In short, it's called the LAR Act, LARR Act 2013. From now on, I'm going to call it the LAR Act. It defines, what this LAR Act does is that it defines public purpose, and for acquisition of land to be given to private companies, 80% of the people whose lands are to be acquired, 80% of the people have to be first, their mandate has to be taken in. If 80% of the people agree, only then can the government acquire the land under the LAR Act 2013. But states like Tamil Nadu, Rajasthan, Gujarat have already either amended the LAR Act or they have enacted a new legislation of their own to permit acquisition even in the absence of public purpose, because states can do so. So states can also enact their own law when it comes to land. Since the 44th constitutional amendment, states have acted like their authority is boundless. So they have acquired land at whim, they have given meager compensation to poor people whose lands are being taken away, they have delayed payments, and public hearing is treated as an inconvenient formality. So these are some of the problems with the LAR Act that still stand, and that was sort of a closure on the whole Singur case. Let's move on to the third editorial. This is on this is from the Hindu newspaper, and this is on how NAM, non-alignment movement, has become inconsequential for us. You know, in lots of previous videos we have done why NAM has been losing its meaning for us. This article sort of defends NAM, and it says that it should stay for about 6 reasons. I'm just going to read it out. Firstly, it says, first, some people say that NAM was just a marriage of convenience at its time, and it's not relevant anymore. But the author defends by saying that NAM signifies freedom of judgment and strategic autonomy. Those values are still valid today. Our strategic autonomy is still valid today. Second, some people say that NAM did not help us out during the Chinese aggression of 1962 or during the Bangladesh War of 1971. The author defends NAM by saying, but NAM's philosophy in the first place was to remain united on larger global issues, and it was not necessarily that we help each other in wars, etc. We also sometimes did not help other members of NAM. Thirdly, some people say that NAM has no ideology. The author defends NAM by saying that it has an ideology. It is anti-colonialism, anti-imperialism, and anti-racism, nuclear disarmament. And because of that, India also did not sign the nuclear non-proliferation treaty. And these values still are valid today also, and that is the whole ideology of NAM. Fourthly, it was useful to us during the times when, for example, India led NAM effort to resolve the Iran-Iraq dispute. Fifthly, NAM will be helpful for our case when we ask for a permanent membership of UNSC. Sixthly, also, it has a heritage value in our foreign policy. Just like we just don't throw away our elderly, we keep them because we have placed our faith and sanctity in them, and they provide the pillars for our morality. Similarly, NAM is our heritage and we just cannot throw it away. Let's go to the fourth editorial. This is from the Indian Express. It's on that whole copyrights issue. We have done it earlier in other videos, in the previous videos, that the University of Oxford Press, Cambridge University Press, and Taylor and Francis, that publication company, they had filed a case against a photocopying shop from Delhi University because they were photocopying their books and selling it in spiral binding. So this article supports the court's judgment that it can be indeed done. Photocopying can indeed be done, and it is not a violation. So, and it gives out about 3 reasons in its support. I'm just going to read it out. Firstly, it says that commercial publication is different from other commercial enterprises because publishers pay nothing as inputs. They just publish books written by researchers and academicians who are basically paid salaries by their respective universities. So, the person who is putting in the real effort here is not getting paid. The publishing companies who are not putting in anything, they are getting paid. The real the person who should really benefit, that is the authors, are getting royalties that are very, very meager. They are almost negligible. The entire royalty on a book could just amount to their 1 month's salary. So, secondly, quality higher education is not compatible with an overzealous copyright law. Thirdly, in today's digital world is making this whole publishing business redundant. Some universities have gone to the extent of they have chosen to challenge commercial publishing through the coalition of open access policy institutions, and these include very hi-fi universities like MIT, Harvard, Stanford, Columbia, etc. So these are the 3 reasons that the author has given in the support of his argument. And that's it for today, 7th October 2016. Thank you.